All right, good morning. We're going to get started. People are still joining us, but they can jump in when they get here. Thank you for joining us today. My name is Ann McGinnis. I am a partner in the school law practice at Schoeneck King, and we are here today to talk about a unique issue, which is the special education entitlement of students who are placed in non-public schools by their parents. And there are some unique laws that pertain to students in this situation. They do have a right to special education. We're going to talk about what that is, which district is responsible. And whenever I do these trainings, I'm always doing it from the worst case scenario lens, which is we have to defend your district in a due process hearing for an issue like what we're talking about today. And when we're defending at a due process hearing, hopefully that'll never come up for you, but if it does, there's two things that we need to demonstrate. We need to demonstrate procedural compliance and substantive compliance. So procedural compliance is that we followed all the many rules and regulations and laws around developing a student's IEP, or in this situation, an IESP, which we'll talk more about. And then substantive compliance is that the document that we develop for that student meets the student's needs and meets the legal standard for that document. So that's the position that I come from when we're talking about this. And if you have questions, you can put them in the chat, I guess. I have access, or there might be a question link, whatever you see, I have access to whatever it is. I will keep an eye on it. We have a lot of content to get through. So depending on how many questions there are, we'll see how many I can get to, but I will keep an eye on it. Now, the law for students who are parentally placed in non-public schools who are entitled to special education classification is 3602-C, lowercase c, and that is also called the dual enrollment law. And it pertains to students who are parentally placed in non-public elementary or secondary schools, and it also pertains to homeschooled students. Today, we're not talking about homeschooled students. We're just talking about students who are parentally placed in non-pubs. When I say non-pub, I mean any type of private school. It could be a parochial school. It could be an independent school. The legal term for it is non-public school, which is the one that I use a lot, but I use that synonymously with private school. It's when a parent has made a decision that they are not going to enroll their child in the public school, they're going to instead enroll in a non-public school. Just so you know, 3602-C, in addition to special education, also has some provisions for students who are parentally placed in non-public schools for vocational and gifted programs. We're not going to get into that today. I believe the term is occupational and not vocational under the law, but there are rights that students have for that as well. Just want to give you a heads up, that does come up from time to time. For students with disabilities, and when I'm saying that, I mean students who are entitled to special education classification and an IEP or an IESP because of that classification, when they're placed in a non-public school, it's the district of location that has the responsibility to provide the special education programs and services to those students. So when I say that, I mean the district where the non-public school is located. So the student's district of residence is not part of that analysis in determining which district provides the services, which district has CSC responsibilities to develop the plan for the student. It is the district of location. So if you're in a district and if there's any non-public schools that are located within your geographic boundaries, you have responsibilities towards the students enrolled in that school, regardless of their district of residence, to determine if they are eligible for a special education plan, and if so, to provide those services. And there's an SED guidance document that I linked in the materials that has a lot of information. We're talking about a lot of that today. So section 3602-C was amended in 2007, and that's when it became explicit that the district of location has that responsibility. The district of location claims state aid for students who are parentally placed in non-public schools located within that district. The district of residence still has some obligations to those students not at their non-public school. We have a whole section on this, so we're going to get to it. But the district of residence could have an obligation to still develop an IEP for that student that would provide that free appropriate public education if the student were to enroll in their district of residence. And there's some specific situations where it's prudent to develop those IEPs. We're going to talk about that. The student's district of residence is also responsible for the costs that are associated with the special education services provided by the district of location. So the district of location CSE convenes, just like any other CSE. The parents are part of that, the team is part of that, develops the document for the student, provides the special education programs and services, and then they bill back the district of residence, and the district of residence is financially responsible for paying for those services. And 3602-C does not apply to summer programs. So we don't provide extended school year services to students under 3602-C. Now, one way that students who are parentally placed in non-public schools can receive ESY, if they're entitled to it, is to enroll in their home public school district, and then that district would develop an IEP for that student for the summer months. The district of residence would have responsibility for the ESY program, not the district of location. Sometimes those are the same district. All right, so I talked about an IESP. We know that our students who are attending school within our district receive an individualized education program, an IEP. Students who are attending non-public schools located within the district are entitled to an individualized education services program, an IESP. They look very similar. There are two different types of documents. If you're using Frontline, make sure that you're using the IESP template when you're developing these documents for students who are parentally placed in non-public schools. And the legal standard for students who are placed in non-public schools is that they must be provided with the special education services on an equitable basis compared with other students with disabilities attending public or non-public schools located within the district. So that equitable basis standard is what applies. We don't typically see that free appropriate public education, that FAPE standard. Case law is starting to blur that line a little bit recently in New York State. But if we're just sticking right to the legal standard, it's equitable basis. What does that mean in real life? It means that the school where the parents have chosen to send their child is responsible for delivering the curriculum to that student. And the special education programs and services that the public school provides supplement that. So we wouldn't typically provide a special class, typically. I'm a lawyer, so I have to qualify everything. We wouldn't typically provide a special class program because that's delivering curriculum, and the parents have chosen this non-public school to deliver the curriculum. But anything that might supplement that the student is also entitled to receive is fair game. So certainly related services, resource room, consultant teacher, those are all things that can be provided. But the CSE should only recommend those if that's what is needed for the student's disability. So if the CSE believes that the student would need a special class program, that wouldn't, for example, automatically entitle the child to resource room to get some kind of special education teacher support. We should only be recommending resource room if the student would otherwise be entitled to resource room and need resource room to address their goals. And the reason why I'm saying the non-pub takes care of the curriculum is because the parentally placed non-public students have to be provided the services based on need, the same range of services offered in the district of location, taking into account the student's placement in that non-public school program. The non-public school program provides the curriculum. We supplement that. And when it says based on the same range of services provided by the district of location, if we offer resource room to students in our school, we can't say, well, we don't offer resource room to students who are enrolled in the non-public school located in our district. We have to provide the same range of services. But the opposite is also true. If we don't offer, for example, we're supposed to offer everything on the continuum except for integrated co-teaching. It's the only thing that's not required on the continuum. So if we don't offer integrated co-teaching, we don't have to then offer that within the non-public school. The determination of how the special education services are provided within the non-public school is made by the district of location. So how, where, and by whom. The services don't automatically take place at the non-public school. It's permissible for the district of location to transport those students back to the district of location to receive their special education services. That's based on a consultation process that public school officials are supposed to engage in with non-public school officials, and the individual needs of students. So the final decision is made by the district of location. There are some circumstances where it would be required to provide the services at the non-public school. So for example, there are some decisions in New York State that say if a student needs direct consultant teacher services, we have to provide those in the non-public school. We can't bus them into our school to receive it because that is supposed to be provided in the gen ed setting, and the student's gen ed setting is the non-public school. So that's an example of when the services have to be provided there. There also might be situations where a student's disability related needs require them to receive their services at the non-public school. That would be a rare situation, but it is within the realm of possibility. That should be the CSE that makes that determination. Are there any disability related needs that cause us to have to provide that service in the non-public school? There's some very compelling reasons for districts busing kids in to the district to receive their services. If there's, I'm going to give you just a concrete example. If there's only one student that receives resource room at that non-public school, it might make more sense to bring that student to the public school to receive resource room, because number one, they'll have a group of students there that they can be grouped with, and resource room is typically in a group of 5 to 1 or less. And number two, it will take a lot of the teacher's time to go from the public school to the non-public school and back. That could take 3 periods total, even though it's only 1 period of service. And these days where we have a shortage of everybody in schools, we need to maximize the number of students that our providers can actually reach. And sometimes busing the students in will allow our providers to be able to maximize that. Those are just some examples of what I've seen come up. The district of location chooses who provides the services. They could contract with BOCES or another public entity. They can provide it with their own people. And if we decide that we're transporting them to our public school, then we have to provide that transportation for the students and any accommodations that they need for that transportation. And parents of a non-public student can submit a due process complaint to the district of location if they're dissatisfied with the special education services that are recommended or being provided by that non-public school. All right, we talked about equitable basis. So it requires that the special education services to parentally placed non-public school students with disabilities are provided in the same manner as compared to other students with disabilities attending public or non-public schools located within the district. We can't deny services that a public school student would be entitled to just because the student's a non-public student. And like I said, we do not have to create programs that we don't offer within our own district. There are consultation requirements that are pretty stringent. I have seen the state, when looking at state complaints initiated by parents, examine those consultation activities as part of their determination if the district has complied with 3602-C. And within those consultation requirements, the district of location must consult with non-public school representatives and representatives of parents of non-public school students with disabilities located within the boundaries of the district. And the consultation process has to include the child find process, which we'll talk about a little bit more, the provision of special education services, including where they're going to take place, how we're going to deliver those, and the use of federal funds for special education. It's not specific to individual students. It's the CSE, the Committee on Special Education, that determines on an individual student basis what goes into that IESP. But consultation is more broad with the representatives of the non-public school to talk about how our public school is going to address the needs of students and work together to figure out how that's going to work. The non-public school representatives have to provide a written affirmation of their participation in the consultation process. And if they don't within a reasonable period of time, then the district has to forward information to SED about that. The guidance document that I linked towards the beginning has a whole section on these consultation requirements. I'm not getting into it beyond this today. So if you're unfamiliar with that, I suggest that you look at that and and familiarize yourself with it. It is important that districts fulfill these consultation requirements. And I find that many don't know that that's an obligation. We have a question. If a parent doesn't want their child to go back to the public school for resource room services, and if they demand to get it at the non-public school, are we obligated to do it at the non-public school? No, not automatically. So the law allows the district of location to determine where the services will take place. They're supposed to consult with the non-pub in this process around that. Now, the exception to that is if the student has a disability-related need for it to take place somewhere. So if a parent is insisting that it take place at the non-pub, then I suggest that the CSE discuss, is there a disability-related need for that? In the majority of cases, the answer to that will be no. And if the answer is no, then the typical process of determining where the service will take place can apply, and it can be at the public school. Now, I do see parents initiate due process around this, and I've seen parents raise various legal arguments for why it's contrary to special education law if the service doesn't take place at the non-pub. And yeah, that's a developing area of law. We are definitely seeing more litigation in this area in New York State right now than we have in past years. Parents under 3602-C are required to request services prior to June 1st of the preceding school year. So they're supposed to put that request in writing. They're supposed to say, I request that my child receive their IESP services for the 25-26 school year. There are exceptions to that. When the student is first identified as a student with a disability after June 1st of the preceding school year, for which the request is made, and prior to April 1st of the current school year, when that happens, if the student is initially classified after June 1st but before April 1st, the parents have to submit the request for services within 30 days after the student was first identified. It is permissible for districts to adhere to this June 1st deadline. There are some commissioners' decisions on that. There are some New York State SRO decisions on that, which is the first level of appeal for a due process hearing. And they have said that that June 1st deadline is enforceable. And there's a reason to enforce it, because we have to figure out how we're going to allocate resources and funds. And if we get many requests after June 1st, that can be difficult to do. It is permissible to go beyond June 1st and to accept late requests, but it is not required that you do that unless the exception exists. All right. Sorry, I'm just keeping an eye on the questions. We're going to get to some of them. All right, let's talk about child find obligations for non-public schools. So child find is an obligation under the Individuals with Disabilities Education Act, the IDEA, that requires us to identify, locate, and evaluate any students with disabilities who are within our schools. And every district has to have a policy regarding their child find activities. It has to be in writing. There's different things that districts have to do to fulfill these obligations, like put things on their website, send out mailings to parents to let them know of their right to refer to the CSE. The Child Find program has to provide notice to the public of educational opportunities available to individuals with disabilities, provide information on the availability of services to local agencies and facilities, maintain a list of individuals with disabilities within the age range who may or may not be receiving services, and post annual child find notices in public places. For students attending non-public schools, there's different child find obligations unique to them under both the IDEA for special education and Section 504 for Section 504 accommodations, which was one of the questions that just came in. So under the IDEA, which is very distinct from Section 504 obligations for child find, Education Law 3602-C, like I talked about, was modified in 2007 to modify school districts' child find responsibilities for students in non-public schools who might be eligible for services under the IDEA. So every school district is responsible for monitoring students who attend non-public schools located within their geographic boundaries. And when we talked about the consultation requirements, that's part of what we have to talk about is child find, because we don't really know who's enrolled in these non-public schools. So we need to make sure that we let representatives of the non-public schools and representatives of non-public school parents know about the CSE referral process and how that works, and how students can be referred to CSE, what conditions might warrant a CSE referral, that kind of thing, to make sure that we adhere to our child find obligations for students who are attending a non-public school located within our district. If our child find obligation is triggered, which means that we have a reasonable suspicion that a student has a suspected disability, the student has to be immediately referred to the CSE for an evaluation. That CSE evaluation looks the same as the CSE evaluations that we provide to our students attending our public schools. And then the CSE convenes to determine if the student is eligible for an IESP. And then the district of location, CSE, if they do develop an IESP, they provide the services and they can usually recover the expenses from the student's district of residence. There was a question about if I'm going to get into that billing back. I'm not. I'm talking more about substantive issues for IESPs today, but there is a New York State guidance document that's very comprehensive on the billing process for recovering the special education services from the non-pubs. So in contrast, Section 504 has different responsibilities. It's the district of residence that has Section 504 child find obligations, not the district of location. It is the district of residence. So the district of location has no Section 504 obligations. The district of residence does have those child find obligations. But this is important, and this is something a lot of people don't know. The district of residence has no obligation to provide the 504 accommodations in the non-public school. The district of residence's only obligation is to develop the 504 plan the student would receive if the student were to enroll in the public school. A lot of non-public schools don't know this. A lot of parents don't know this. A lot of public school districts don't know this. So we do not develop Section 504 plans for non-public schools. We only develop plans that we would implement if the student were to enroll in our school. And we give it to the parent and we say, if your child were to enroll, here's what we would do. The parent can choose to share that with the non-public school if they want. If the student needs 504 accommodations in the non-public school, it is up to the non-public school to determine, number one, are they obligated to provide 504 accommodations? Because they are only obligated to provide them if they receive federal funds. So if they don't receive federal funds, they do not need to provide those accommodations. But number two, if they do receive federal funds and if they're obligated to provide the accommodations, the non-public school determines what those accommodations are and implements them on their own. They're not required to use our document. They are actually not even required to use necessarily a Section 504 plan. They can go about it their own way and determine how they're going to provide those Section 504 accommodations, which again, they're only legally obligated to do if they receive federal funds. Now, some exceptions. If that student is coming to the district of residence for something, let's say they're coming to the district of residence to take their Regents exams. If they need 504 accommodations when they're at the district of residence, then the district of residence has to provide that. If they need 504 accommodations while being transported and the district of residence is transporting them, then the district of residence needs to provide that. So if the district of residence is ever interacting with that student and the student needs 504 accommodations during those interactions, the district of residence has to accommodate. But as far as accommodating at the non-public school, a public school district does not have an obligation to do that. Just checking the questions. All right, now we're going to talk about unilateral placements in non-public schools due to parent disagreement. So this is different. What we've talked about up to now is when a parent just makes a decision for whatever reason. There's lots of reasons why parents may decide to do this, to place their student in a non-public school, and they ask for special education services from the district of location through an IESP. Now we're going to talk about what are the obligations to non-public school students who are placed in the non-public school because the parents disagree with the special education program, the IEP developed by the district of residence. So we see this come up in a variety of situations. But if you have a student with a disability and the parents don't agree with the IEP that you as the district of residence developed, they may decide to do something called a unilateral placement into a non-public school. And we're going to talk about what are the obligations when that happens. Because once a student is unilaterally placed in a non-pub, the district of residence is vulnerable to a due process hearing complaint where the parents can try to recover tuition reimbursement, and that can get very expensive. Some of these non-public schools, especially residential programs, can be $250,000 a year, and they're mostly not state approved, which means that we can't get state aid for them. So here's a summary of what I just talked about. It's called a unilateral placement. If a parent believes that a school district of residence, this is the school district of residence, has denied their child a free appropriate public education, the parent can choose to remove their child to a private placement, to a non-public school. Parents can also place their children in non-pubs for reasons that have nothing to do with dissatisfaction. So parochial schools, other gen ed private schools, and those are students who are entitled to an ISP, which was what we already talked about today. Students placed in private schools, parents will sometimes unilaterally, I already talked about this, I'm sorry. So this all has to do with the district of residence. So if a parent unilaterally places their child in a non-public school, the district of residence still has an obligation to make a free appropriate public education, a FAPE, available to its resident students, even if those resident students are receiving an IESP from the district of location. That doesn't get us off the hook. So we still have an obligation for our residents, regardless of where they're going to school, to offer an IEP every year that provides that free appropriate public education in the least restrictive environment. Now, in reality, we should be sure that we're developing these IEPs for students who we know are placed because of parent disagreement. Is there a legal argument that any student who is placed outside the district by their parents who's qualified is entitled to an IEP developed by the district of residence every year? There is, but in many situations, that's just not feasible for various reasons. But if we know that the parent is dissatisfied with our district and what we offered, and if we know that they placed their child outside because of that, we need to make sure that we have an IEP developed for that student every year. Here's some examples of when we see this come up. When students are placed in a non-public school to address a student's disability-related need, there's a lot of non-public schools that focus on dyslexia, for example. There's non-public schools that focus on students with autism. There's non-public schools that specialize in certain areas of disabilities. If we know that a parent has placed their child in one of those schools that specializes, we need to make sure that we have an IEP developed for that child every year. Students who are placed in residential programs, that's a big indication to us that we need to make sure that we have an IEP, because that's when the tuition can get exceptionally expensive. We're also now seeing, which we didn't see before, that sometimes parents are initiating due process for students enrolled in private gen ed schools, like a parochial school. That's a little bit more difficult for a parent to prevail, but we have gone to hearings on that issue. So just something to be aware of. Now, if a parent initiates due process for their unilateral placement, they have to prevail on 3 prongs in order to be entitled to tuition reimbursement from the district. The first prong is the most important prong, and it's the district's burden to prove that it offered the student a free, appropriate public education. This is why you need an IEP. This is why. If you don't have an IEP, you can't prove that you offered a FAPE. And it's very hard to win these hearings if you don't win the first prong. So that's why we need to have an IEP in place every year to be able to defend if the parent initiates due process. The second prong is the parent's burden. They have to prove that the private unilateral placement is appropriate for the student. This is typically a pretty low standard for parents to prove. They're able to demonstrate that the unilateral placement is appropriate. They don't have to adhere to that same FAPE standard in the least restrictive environment for their placement that we have to adhere to for our IEP. So it's a pretty low standard. Parents are usually able to prove that. And then number 3, the parents have to prove that the equities favor them. That's also fairly easy for them to prove. They have to be cooperative in the IEP process. They have to attend the CSE meetings, go to intakes if we're recommending out of district programs, that kind of thing. So that's why that first one that we offer to FAPE is the most important one. Parents are required to provide a notice of unilateral placement. They can't initiate due process for at least 10 days after they provide that notice. There's two ways that they do it. The way that we see most frequently is in writing. And if you get a letter saying that I disagree with the IEP developed by the district, I am placing my child in a non-public school and reserve my right to recover tuition reimbursement, I'm placing my child in a non-public school, this is a unilateral placement, anything like that, you should call your attorney. Because you have 10 days to reconvene the CSE to make that IEP be the strongest IEP you can. If you get that letter and the child isn't classified, you need to refer them immediately. And you need to do that evaluation as soon as possible. If you go beyond 10 days, there's an argument that we might not be able to use the resulting IEP to defend the district. So we really have those 10 days. We have to do it as quickly as possible. It's a good idea to respond to them in writing, reconvene the CSE. Even if you think the IEP is great, it's still a good idea to reconvene the CSE, have your attorney look at the IEP to make sure it's as legally defensible as possible. The other way that parents give notice of unilateral placement is they'll verbally say that at CSE meetings sometimes. So at the end of a CSE, they might say, I disagree with the IEP just developed by the CSE, and I reserve my right to recover tuition reimbursement. We're unilaterally placing our child at this school. If that happens, don't end that CSE meeting until it's the best IEP can be, because you don't really get another bite at the apple when they verbally give it that way. I've made that argument with parent attorneys that we can reconvene. We've hashed that out. It's had different types of outcomes, but that's an indication to you that due process is likely coming, and don't end that meeting until it's the best, strongest IEP it can be. Make sure you ask the parent what their specific concerns are. And if the CSE agrees that those are areas of need, make sure the IEP is very thorough in how it addresses those concerns, and then call your lawyer. So when we're developing these IEPs, a few tips: make sure the district's recommended IEP complies with all the procedural and substantive requirements. Be sure that the IEP has an actual placement on it. It's very difficult to prevail at these hearings if the student has home or hospital instruction pending placement in an out-of-district program. It's very hard to prove that home hospital instruction provides a free, appropriate public education in the least restrictive environment, unless the student is truly too medically fragile to attend school. So it's risky to not have a placement. If you think the student needs to be out of district, but you don't have a placement, develop an in-district program for the student that is the strongest program you can recommend. Make sure you can actually implement that. So if you don't have a 611 special class, don't put a 611 special class in district on the IEP if you can't actually implement that. The IEP should be developed as if the student's coming to us. So even though we know the student isn't, it feels like this fictional world. There might be a universe where the parent is happy with the IEP and does send the student back to us. But regardless, it should be developed as if the student's coming to us. Continue to hold annual reviews every year to update the IEP. You have to always have an updated IEP in place that we can implement. You can request that the parents invite members of the non-public school and provide updated information regarding the student's present levels of performance. We can ask for parent consent for us to ask for that. It's hard for us to know what the present levels of performance are if the student isn't being educated by us. But it's still our obligation to figure out what that is. So we do that by asking for information from the non-pub, anything they have around progress monitoring, evaluations, the type of programs and services they're giving. We want anything they have that can help us identify the students' present levels of performance. And we still have to conduct those 3-year reevaluations as well for those students. So keep an eye out on that. Make sure those are very thorough. We're basically always treating this student as if they are coming back imminently, and we want to have a very strong program in place for them. Sometimes we learn that a general education student has been unilaterally placed. I talked about this a little bit. You need to, again, you only have 10 days after that notice of unilateral placement. Refer that student to the CSE immediately. In an ideal situation, that evaluation is done and the CSE convenes within 10 days. I've seen it happen. It's harder to do over the summer. I've seen it happen. because going beyond that 10 days makes it more difficult. We have a child find obligation to identify our resident students with disabilities. So if parents unilaterally place, they could say you violated your child find obligation. We had to unilaterally place. It's a strong argument for them. Our employees should also know, if you hear that a student has been placed in a residential out in Utah, most of them are out in Utah, you need to make sure you let a supervisor know that, because then we can get ahead of it and we can make calls and say, hey, I heard that your child's in a residential. Can we talk about that? And maybe we can refer the student sooner than getting a notice of unilateral placement and have a little bit more time. Maybe in an ideal world, we can work with parents and try to help the student come back. That would be great. All right, we have a lot of questions, so I'm going to take a look at those. All right, here's a question. If the non-public school determines they are not obligated to provide the 504 accommodations except through a special education process, how does the district of location navigate the need they determine does not meet IESP level but should be supported through 504 accommodations? So we should probably refer that student to the CSE, do a CSE evaluation. Only the CSE has the authority to determine that the student is ineligible for an IEP or an IESP. Something that I caution against is many districts provide related services on 504s, and that's permissible, but it's also permissible to provide only related services on an IEP or an IESP. So if you're a district that would typically provide counseling or speech on a 504, if that's all the student needed, if you have a non-public student who needs that, you should give them an IESP. It's not defensible to say, well, if they came to us, we do it through a 504, but we don't have to give you a 504 because you're in a non-pub, so you don't get it. Because we know that they need it, they can get that through an IESP. So if there's any services that they need, we should do that through an IESP. If we determine all they need are accommodations and the CSE makes that decision, there's no special education programs or services they need, finds a student ineligible, we have no obligation to provide Section 504 accommodations to a student in a non-public school. And it doesn't matter if the non-public school says they're not required to provide accommodations. Many non-public schools have determined that they don't receive federal funds, so they don't need to provide those accommodations. That does not trigger an increased obligation on the public school district. All right. Another question, if a parent does not consent to the initial provision of special education services, does that allow the district to no longer make an IEP available each year? Yes. Yeah, if the parent doesn't consent to special education services, or if they revoke consent or to special education services, we can't develop an IEP because they have said that they don't want those services, and that is their right to do. Now, an exception to that is, let's say a parent hasn't given consent or has revoked consent, and then the following year you get a notice of unilateral placement. I would refer that student back to CSE and ask the parent for consent to do a CSE evaluation for an initial referral. If they don't give consent, then we are building a defense that the equities don't favor them because they weren't cooperative in that CSE process, and a defense for why we can't provide a free appropriate public education. Is the district of residence obligated to pay the district of location if they do not provide the required consents and documentation to the district of residence? Yeah, I believe so. I haven't looked into that specifically, so I would have to check back with that state guidance, but there's very little that the district of residence can do. It's kind of a weird system because the district of residence has no control over the special education programs and services that the district of location identifies and provides for that student. And it could be, you know, the Cadillac of services, and maybe the district of residence thinks that they're over servicing the student, but that doesn't matter. They still have to, they don't have any CSE, they don't have any CSE role in that. Their only role is financial. Do private schools have any obligation to provide MTSS RTI for students or science or reading? I receive referrals to CSE, but there is often none of that prior to the referral. Good question. No, they have no legal obligation to provide MTSS or RTI services to students. We see this come up as an issue because we know that we're supposed to use the RTI process. Sometimes people disagree with me, but We know that we're supposed to use the RTI process to identify a reading disability in grades kindergarten through 4, or MTSS, under the regs. And I've seen public schools say, well, we're not going to classify the second grader who has a significant discrepancy in reading and cognitive ability because the non-pub has not used RTI or MTSS. That is not a winning defense between us. I don't think that's a winning defense because private schools are not required to provide MTSS or RTI. There used to be an SED guidance document on this, but the link is broken now. I can't find it anymore, but it was out there that explicitly said that non-pubs don't have to provide it. So I think that I think it's risky for CSEs to rely on that in finding a student ineligible. I think we need to use our evaluative data to figure out if a student is eligible when they're in a non-pub. Okay, if the student is not currently receiving an IEP or ISP, school makes referral immediately and parent either does not make child available for assessment or does not consent to the evaluation process. Does that factor into the legal argument that the district of location tried to provide a FAPE? Yeah, it does. And it's not a FAPE, it's equitable services, by the way. Although that line is blurring, but I'm still sticking to that the legal standard is equitable services for students with IESPs. Yeah, that gives us a defense under child find that we tried and the parent didn't make the student available. If the parent has a right to not consent, we can initiate due process to compel an evaluation. In practice, that rarely happens because we can't use due process to compel a parent accepting special ed services. So we do the eval, we find that we would classify the student, but if the parent doesn't sign off, that's their absolute right. There's nothing we can do to challenge that. But we fulfill our child find obligation by putting that referral out and making we have to do our due diligence and making attempts to try to contact the parent to see if they want to sign that. There is a provision of the regs that we can go beyond the 60 days to complete the evaluation if the parent doesn't make the student available for an evaluation. I would document all of that. I would make sure you're contacting the parent many different ways: phone calls, emails, mail, maybe somebody goes to their house. Just examples, document all of it. So that we can build up our defense that we met our child find obligations. All right, I covered the district of location's obligation regarding child finds. You have to do consultation with the non-public school representatives and parent representatives of students at the non-public school to talk about child find and what that is and engage in child find activities in accordance with your policy. There are a lot of obligations on the public school district of location's part to get in there and engage in child find obligations. And a district of residence also has child find obligations. And that's hard to do. That's very hard to do when you don't know who those students are and they're placed in a school outside the district. But we defend that based on going back to the policy and all the child find things that your district has done every year to show that we've met that obligation. Can a school for learning disabilities remove a student based on attendance if they were placed there by the CSE and it's the most appropriate placement, the parent wants that placement? So an out-of-district placement cannot unilaterally remove a student from the program. Only the CSE can do that. With that said, a lot of out-of-district placements do it, and there's not much a district can do about that. You could complain to the state, but you usually need those non-public schools to be working with you, those out-of-district public or private placements who are state approved to work with you. So most districts will not go to the state on that, but only the CSE has the authority to remove a student legally. If a student is in a non-public school, receives test accommodations and resource room services, is a resource room provider responsible for ensuring the testing accommodations? Yeah, or is it the responsibility of the non-pub? Technically, it's our document, we're obligated, but most of those accommodations, we need some help from gen ed teacher to do that. So ideally, we're working with the non-public school to figure out how to do that through the consultation process, and we're working together, but ultimately the district owns that document, the IESP. If the student is in need of a reevaluation, should it be done by the district of residence, the district of location, or both? Well, if you're doing an IESP as the district of location, you have obligations to do those 3-year reevaluations. If you're developing an IEP as a district of residence because of a unilateral placement, you also have that obligation. So you can work together. You can get those evaluations from each other, and then you should independently determine if you should collect any additional data. You can only get those evaluations from each other if the parent gives you consent, by the way. So if the parent doesn't give consent for that, then you can't. Okay. All right, it's 8:45 and I got through all of the questions, I believe. So thank you so much for your time today. If you have any follow-up questions, you can reach out to one of the attorneys that you work with. And I hope you enjoy the rest of your day. Thank you.